Members of the Amazulu Royal Family continued their battle in the High Court in Pietermaritzburg today. It's coming down to the wire between tradition, culture and civil law. Professor Chitja Twala, a political historian from the University of the Free State, joins me now. Prof, good evening and thank you so much for your time. It's been fascinating watching this case unfold because on the one end, it's literally just the fight for a spouse who feels that she has been disenfranchised, and yet the ramifications of that fight include so many other people and I suppose in many ways the future of the royal household.
Thank you very much, Meketi, for having me here. You know, in isiZulu, there is a saying that says, "Impi yomndeni kayingeno," which simply translates as that if there is a conflict in the family, outsiders should not join, because when the conflict is resolved, and then the outsiders will be languishing in the periphery. It is important to understand that historically, in all events, the royal household, there sometimes be clashes from the people within. And this is not new. But what is disturbing about this one, it is that the whole issue and the whole question of cultural history and the tradition itself, it is taken to the Western courts to be dictated by the Western courts and the Western laws in order to come up with a determination of who is right and who is wrong. And in this case, when we look at uNdlunkulu, the Queen Sibongile Dlamini Zulu, taking the matter to court, it boils down to the whole question of conflicts, and everybody is drawn into that picture now, and then it can create more problems than coming up with solutions. Because when she is challenging the nullification of the other 5 wives in terms of the marriages, and then one would ask a question as, on what basis is that 50% based on? Because the other wives also are wives, despite the fact that they are customary wives, and then the fact that she is married in a civil way. And then that can create more problems, and then we need to guard against that in terms of our history and in terms of cultural history.
But do we not live in a country and do we not have a judicial system that does have an appreciation for customary law, that even when presiding over this matter, it is not merely about saying, well, this is a civil marriage and that's the beginning and the end of the story. So I'm speaking to your point which says taking this matter to court may not necessarily have been the right thing for her to do.
Yes, remember culturally, we do have royal councils. And before a matter can be taken out of the royal house, one would want to believe that it should be dealt with internally, and then the resolution be met internally before the matter could be taken into the courts. Because if you take the matter such as this one into the courts, it compromises the very same royal house, because it puts the dirty linen into the public as to that there is conflict, and then the conflict should have been dealt with internally. And then I guess if there are problems internally, there are councils that should deal with such matters in order to come with a determination as well as coming with a resolution in such matters. Because here we are not talking about any other person. We are talking about the royal house, and we are talking about individuals within the royal house. Therefore, if this spills out, it is going to affect the whole Zulu nation, and not the only Zulu nation, but the South African at large.
Professor Twala, are we not past an era where the expectation that there are things that can be dealt with exclusively behind closed doors, where that might no longer be possible because you have so much greater interest in the issues that are taking place in society. But also, the means of communication have, multiplied in so many different ways that sometimes trying to keep information only, makes things worse. It doesn't necessarily make it better.
It is not a question of keeping information inside. It is the question of trying by all means to resolve the matters internally. And then remember here, we are also trying to protect the very same cultural history and then our heritage and legacy. We cannot take these things and say, because now we are living in another era, therefore we relegate everything that is old and try by all means to paint it as barbaric. Even if we are living in the new era, but we need to protect what is cultural and what is African in an essence, because South Africa might be part and part of the global world, but it is an African country in an African continent. And then I want to argue that some of the solutions that we need to come up with, they are African solutions and not Western solutions to solve African problems.
When we look at the person of the Queen Mother, ultimately she enjoys every right, like any other South African, to take whichever matters she wishes to and put them before a court of law for arbitration. She's certainly not done anything illegal. Is there expectation that she would have dealt with things differently based on the expectation that not just the Zulu nation, but that society has on somebody like her? Because, well, you're married into the Zulu royal household. You know how we do things here, and therefore you should abide by the system. You should play in the system.
Why would a person not play with the system if the person is married within that particular culture and that particular system? And then why would a person try by all means to go against the very same system that a person says she or he is abiding by and abiding with? Therefore, it is important that we need to also to check as to whether were internal processes taken good care of and exhausted before going to the courts. If then that is the case, then one has got all the rights in a democratic era to can take the matter to the court. But I am saying here that we are talking about a royal house. And then by mere fact that it is a royal house, it needs to be respected in terms of tradition.
What about her individual agency by being part of the royal house? I would certainly not think that she then also effectively signed off every other right that she would have to pursue any other matter in the way that she felt was in her best interest. And I'm saying this specifically through the lens of her as an individual, because that's how she has brought this matter before the court.
Yeah, I don't dispute that there is an agency on the matter itself, and then that is acknowledged. But at the same time, we also need to recall that the agency that is in this matter will also trigger other agencies from other people who might also try and go the legal route. And then it will be a revolving door without an end, whereby a person, for example, if she is trying to nullify the other wives, the very same wives will also go the legal route and say, we are also going to get our lawyers in order to prove that we are legitimate in this marriage. And that is going to be a revolving door. Unless we are prepared as a country, and then unless we are prepared as the royal house to go that route, let it be.
Will it not lead to the development of law in this country across the board?
It is unfortunate that in law there are three sides. There is the one which is your side, and the other side which is the side of the complainant, and then there is a third side which is the truth. And then if this will lead to the development of law, and perhaps customary law, and let us go that route. But that will come at the expense of the destruction of the very same tradition and in terms of the royal house.
Let's leave it there for this afternoon. Professor Chitja Twala is a political historian. He's with the University of the Free State.